The Sessions Court at Goa acquitted Mr. Tarun Tejpal, the former editor-in-chief of Tehelka, a very, very famous sting operations newspaper, website, magazine. And there were some very, very interesting things that I wanted to talk about. Now, this particular case struck my attention way back, even when the allegations were put. And this was at that point of time in November of 2013. It ended up as national news. And something very, very interesting about this case is that this was one of the first few cases which gained a lot of prominence, where the Criminal Amendment Act of 2013, where several amendments were made post the Nirbhaya gang rape situation. These reforms were made, and the scope of rape, the definition of rape was expanded widely. And this is one of those cases which, if it would have taken place perhaps a few months prior, the offences of rape punishable under section 376 would not even have been applicable. But because of the introduction of the Criminal Law Amendment Act of 2013, the changes in the definition of rape by the legislature, this particular act allegedly done by the accused person over here, now acquitted person, came under the ambit, at least when it comes to an allegation of rape. The allegation was that the complainant lady, who was also working in the same organization with the accused person, said that she was there chaperoning Robert De Niro, the famous Hollywood actor, at an event hosted by Tehelka itself, the editor-in-chief of which the accused person was. And her duty was there to chaperone Robert De Niro and his daughter, who were there at the incident, at the place of the incident. And as per the allegations of the lady, she, after seeing off the guest, she and the accused person walked into an elevator. Person who she knew for several years, a person who she was under the employment of for several years. And this is something very relevant for us to remember as well for a few minutes down the line. And this lady, alleged that the man came and kissed her forcefully and then took down her undergarments in the lift itself, and inserted his tongue as well as his fingers into the vagina of the complainant. She comes out. She is very, very afraid, but the moment she comes out, she rushes to her hotel and she narrates the incident to her friends, who are also her colleagues, which is another relevant factor over here. After this, the next day, but she is afraid, there is De Niro to take care of, there is the event and everything else. She does not make any formal complaint anywhere. Next day, she also goes about her day. Again, as per her allegations, she gets into a situation with the accused person again, where he again tries to get inside an elevator with her and kisses her again and tries to again start another sexual endeavor with her. She puts up a lot of resistance and runs out, and even while she is getting out, he again grabs her buttocks as well. As per the allegations, she then goes and talks to the daughter of the accused person, tells her, who was her best friend at the time, and she goes and tells several other people in the organization about this entire ordeal. The lady then, after precisely 10 days from the date of the incident, first files an email complaint with the Internal Complaints Committee of the organization, which is mandated to exist under the Prevention of Sexual Harassment Act. In response to that email complaint, the accused person also writes an email expressing his regrets to the lady as well as to the organization. Of course, he does not admit in entirety to the allegations that she had made, but he, expresses his regret about actions which he is ashamed of. That was, in brief, a nutshell, the contents of the apology letter. Meanwhile, the Goa police looks at the national headlines and establishes for itself that a crime has been committed within the jurisdiction of Goa, and therefore suo motu, that is of its own accord, starts an investigation into the incident. The Goa police writes to the chairman of the Internal Complaints Committee, does not get any reply. Then also receives a letter from the, I believe, the National Commission for Women, and then launches an FIR. Writes, reaches out to the accused person and asks him to join investigation. He doesn't. He applies for bail here and there, and ultimately he is arrested in the month of November 2013 itself. And he is ultimately granted bail by the Supreme Court around July of 2014. And it is very, very funny to notice over here that in July of 2014, the Supreme Court, the apex court of the country, directs the trial court to expedite the trial and wrap it up as quickly as possible, and in no circumstance extend it beyond 8 months. This was July of 2014, and now we are here in May of 2021 that the trial ultimately ends and the verdict is pronounced by the Sessions Court. The reasoning given by the Sessions Court in a 500 plus page judgment, disclaimer, I have not gone through the judgment. I have read credible news sources which have talked about the judgment and what was the reason for the trial court to acquit the accused person. And of course, these are reasons given almost in every single criminal trial. So, we have no reason to doubt the reports of these news websites which have given these reasoning of the Sessions Court. However, there was one place where I was able to, in a huge amount of substance, I was able to look at the entire charge sheet which was compiled. I will put a link to that news website. I believe it was India Today. I will put it in the description. You can go through it, and for all you law students and young lawyers, I would definitely recommend you take out the half an hour, 1 hour required to go through the entire article, which is basically, in summary, the charge sheet. And so you get to see in entirety how the investigation is done by the police in an allegation of rape. It's very, very interesting. Anyways, the police filed the charge sheet under sections 354, 354A, 341, 342, section 376, and certain other provisions under 376 itself, which make the offense punishable with even higher amount of imprisonment. And this is also very interesting, which is very relevant here, as I mentioned earlier, because the allegation was by a lady against a person who exercises to a certain extent superiority over her. To a certain extent, he exercises control over her, and he has a power and he has a place of influence over her, which was considered by the legislature, of course, with the help of the Verma committee back in 2013. And they had said that if a person in power or influence over another person commits rape upon that person, he shall be guilty of, he will be liable to be imprisoned for a term higher than if that was not the situation. So ultimately, after several years, what was the reasoning of the Sessions Court? The reasoning of the Sessions Court was, which is a very, very, something that happens on a very, very regular basis. In 2018, a client of mine was also acquitted in a very, very famous case, which had a lot of news coverage. The same language, the same verbiage was used by the magistrate in Delhi, which was used by the Goa Sessions Court, which is as follows. There are several inconsistencies. There are several improvements in the statements of the complainant. There are several omissions, and there are several change of versions by the complainant which do not inspire confidence. These were the words used by the Sessions Court, and therefore, coupled with several other glaring discrepancies, glaring difficulties in the case of the prosecution, the court decided to acquit. The court held special emphasis on the fact that the investigating officer deliberately kept out certain CCTV footage procured of a certain floor, which could be showing the complainant as well as the accused person walking out of the lift. The court also took strong exception to the fact that the complainant lady was not able to explain how is it that the accused person was able to keep the lift doors closed for 2 minutes precisely, which is the description of the time that the Sessions Court also very, very strongly considered the aspect that the complainant, the investigating officer are both the same persons. What had happened in this case was, usually in a police case, especially in an allegation of rape, the complainant is the lady who actually went and filed her police complaint with the police station and said that this is the thing that has happened with me. In this particular case, as I mentioned earlier, the lady had just filed her complaint with the internal complaints committee. She never approached the police at all. And the police, which it has the power to do so, did indeed go and file and register an FIR on its own accord. And the difficulty, the little mistake that the police did was, the same lady complainant who had registered the FIR was the same person who then also went ahead and investigated, took the statements, and did everything else in the matter by herself. A practice which has been deprecated by the Supreme Court on numerous occasions. So much so to say that the Supreme Court very recently also mentioned that if the complainant and the investigating officer is the same, then it is a ground for acquittal, which also weighed very, very strongly with the Sessions Court as well. Now, the Goa police has approached the Bombay High Court bench at Goa with an appeal against acquittal of the accused person. Now, of course, the acquittal is there, and the principle of proof beyond reasonable doubt, that is the reason why the Sessions Court acquitted the person in the first place. But I believe that the accused person is not completely out of the difficulty that is posed to him, because a couple of things which I do not know, because I have not been able to read the judgment, I have not been able to get my hands on the judgment. Couple of things which will play very, very strongly will be the fact that whether the delay of 10 days between the complainant lady, experiencing the incident, experiencing the acts against her, versus her filing her complaint with the internal complaints committee, and even then not approaching the police at all. So the complainant lady says that on the 7th and on the 8th of November 2013, these were the incidents that occurred with her. And then on 18th of November 2014, after a gap of exactly 10 days, she went and filed her complaint with the ICC. Now, but the fact that I also mentioned that she mentioned to her several friends, I don't know what transpired, what was the evidence of those friends whom she says she told on the very day the act was committed. Did they inspire confidence? Were they consistent with their statements? And I don't know what is the precise inconsistency or the improvement or the omission in the statements of the girl. But one thing that we need to realize is that the way the criminal justice system in this country works, of course, we expound, we promote the ideals of proof beyond reasonable doubt. One aspect is the courts, they do as they please. These are principles, we love to talk about them, but when it comes to implementation of these ideals, when there is a judge sitting over there, it is the heart and the soul of the judge that matters to him or her. Nothing else matters. So if the judge wants, the judge can say that these statements, minor omissions, are acceptable, as has been held by the Supreme Court in XYZ case. So there is plenty of jurisprudence for the court to go either ways. Yet in this particular situation, a couple of things which will greatly affect the outcome of the appeal also, before the High Court as well as undoubtedly before the Supreme Court as well, will be the time difference between the girl experiencing the event and then going and narrating it to somebody, and that somebody then also corroborating her version before the trial court. Apart from that, something which weighs greatly against the accused person is the letter of apology that he wrote to the institution as well as to the complainant lady. But doing that is something that casts a huge amount of aspersion on the accused person. Apart from that, there are several messages exchanged between the parties which also kind of insinuate towards to a little extent towards a probable guilt of the accused person. All of these things considered, I would say that there is still a possibility that the High Court of Bombay bench at Goa might interfere with the verdict, And if the High Court does not, maybe the Supreme Court will. Of course, as I have mentioned in the past, good legal counsel is something that is very, very important. And Mr. Tejpal had it. And of course, he will be represented by the best, I am sure, at the Goa bench as well, and at the Supreme Court as well. These are some very, very interesting concepts that I thought that, a lot of people would want to understand, would want to kind of appreciate, especially in the landscape of the growing number of rape cases, some true, where the victim does not get justice, and some false cases where the innocent accused person also, in a certain sense, does not get justice, because justice delayed, justice denied, several years of trials, like in this case as well, and the off chance that you spend several months in jail, like Mr. Tejpal did as well. I believe he spent about 6 or 7 or 8 months approximately in custody as well. But whatever happens, we'll be here, and we'll be watching as well.